Now, liquidated damages are important in a variety of contexts, variety of commercial contexts. They're very common in the construction business, but they go way beyond that and come up in a lot of other contexts too. So that's what we're going to talk about in this presentation. Now, the starting point, a helpful starting point, is section 356 of the restatement, which just says what you'll see in a lot of the case law. Damages can be liquidated in the agreement, but only at an amount that's reasonable in light of the anticipated or actual loss caused by the breach and the difficulties of proof of loss. And an unreasonably large LD provision is unenforceable on grounds of public policy as a penalty. Okay, so what it means to be liquidated is to say that at the outset, okay, if I breach, then shame on me, and we're going to agree up front that I have to pay you X dollars for my breach. And these can be one-sided, where I'm the only one who has to pay a liquidated amount in the event of a breach, and if you breach, we just leave that to the proof of loss at a trial if it comes to that. And so that's what it means to be liquidated, just a specified amount. Okay, so for example, I'm building a house for you and you want it by December 31st, and we agree that if I'm late, I have to pay you $500 a day for every calendar day after December 31 that I fail to achieve completion of the house. Something like that. And those are fine as long as you touch certain bases. For example, the amount has to be reasonable in light of the anticipated loss caused by the breach. For example, what's the loss to you of my not having the house done on December 31? Well, it may not be 100% clear what your losses might be at the time we're entering into the contract. It might be difficult to say. Maybe you've got your current house on the market and you expect to have it sold and to be moved out, and if your new house isn't ready, you're going to have to put your stuff in storage and go live in a hotel someplace until I get the house done. Okay, rather than have to anticipate all of those possibilities or wait and hope that you're going to be able to prove up all of the damages that accrue to you from my late completion, we just agree up front, all right, $500 a day. And if that's reasonable in light of the anticipated loss, that's one base that you've touched. Now, a second base that's in the baked into the restatement that you don't always see in the case law, it varies from state to state. You notice it says anticipated or actual loss. And what this is what's known as the second look doctrine. Some courts will take a, quote, second look at the liquidated damages clause to make sure that it's reasonable. It's a second look in the sense that the first look is, okay, at the time of contracting, is this a reasonable amount of LDs given the likely anticipated loss? The second look is, okay, at the time of trial, does it still look reasonable in light of the actual loss that the injured party has suffered? And so sometimes you'll have courts that apply a second look at the LD provision, and that varies from place to place, and so you just need to be aware that that's a possibility. The next base that the valid LD provision has to touch is that the difficulties of proof of loss. That is, the kinds of damages have to be inherently difficult to prove. What would it cost you in terms of hassle to have your house delayed by a month or 2 months? That might not be totally easy to prove. The thing that a liquidated damages clause cannot do is be a penalty, right? Because we don't have punitive damages for breach of contract. If somebody breaches, then they have to pay damages, but we don't want to penalize them. And there are lots of reasons for that we don't need to go into right now. But just accept the fact that if you've got an unreasonably large liquidated damages clause, so for example, I'm building you a house and it's supposed to be done by December 31, and we agree, even if I agree, okay, that if I don't have it done by December 31, I have to pay you $5,000 a day or $10,000 a day for every day I'm late. That's probably an unreasonably large liquidated damages clause, because it wouldn't take all that long before the LDs have added up to the price of the whole house, and I'd end up getting paid nothing. Okay, so we can't have that. The whole point to an LD provision is to try to make proof easier when you're talking about an inherently difficult kind of damage to prove. So illustration 3 is a fairly straightforward example of what I was just talking about. Contractor agrees to build a grandstand for the owner's racetrack for $1 million by a specified date, and to pay $1,000 a day for every day's delay in completing it. In construction terms, this is referred to as a liquidated damages for delay clause. These are very common. Contractor delays completion for 10 days. If $1,000 is not unreasonable in light of the anticipated loss, and actual loss to the owner is difficult to and the actual loss is difficult to prove, as it might be in a racetrack, for example, right? Because if it's not 100% clear how much loss the owner has suffered by having a grandstand come online later than what the owner was planning, has the owner really lost business? Maybe, maybe not. It's going to be hard to prove, etc. If $1,000 is not unreasonable in light of those circumstances, then the contractor's promise is not a penalty, and it's an enforceable liquidated damages clause. Fairly straightforward. Okay, illustration 4 gives a little twist on this and illustrates in a way, the second look doctrine. Facts being otherwise, as stated in illustration 3, right? The contractor building the grandstand. Owners delayed for a month in obtaining permission to operate the racetrack. Okay, so the owner has been delayed through the owner's own fault, or at least not the fault of the contractor, in opening the track for a month. Okay, so the 10 days that the contractor's late has caused the owner no damage, because even if the contractor had completed on time, the owner still wouldn't have been able to operate the racetrack. So it's clear that the contractor's delay has caused the owner zero damages. Okay, since the actual loss to the owner is not difficult to prove, i.e. zero as a result, the loss to the owner as a result of the contractor's 10-day delay, since that loss is zero, contractors promise to pay $1,000 for each day of delay that the contractors experienced in completing the project. That LD provision is in effect a penalty, right? It'd be $10,000, essentially a windfall to the owner, because the owner in fact hasn't been damaged by the contractor's delay. The owner's been damaged by not being able to operate the racetrack because the owner didn't get permission to do so for a month later than what the owner was anticipating, but that's not the contractor's fault. So in that situation, the owner's actual loss is zero, therefore $10,000 worth of liquidated damages is pretty clearly a penalty and wouldn't be enforced. So liquidated damages clauses are a very common kind of contractual provision, especially in construction contracts where there are liquidated damages for delay. They come up in other contexts as well. And the essence of the idea is that parties agree up front on what the damage will be in the event of some specified breach. And those are generally enforceable, provided that the different bases that are listed in that section of the restatement are satisfied, so that a court will view the liquidated damages clause as enforceable and not simply a penalty.